Well, while those who are getting lunch are trickling in, we're going to go ahead and get started so we can maintain faith to the CLE minutes requirement and get you all in and out of here and back to work in a timely fashion. I'm Janet Levitt, the Dean of the Law School, and I'm so pleased to welcome all of you, students and members of the bar and faculty and staff here to our fourth Faculty Showcase CLE series. This is something that we began in the fall. Two of the architects, Leslie Shelton and Charles Hogshead, are here, and it's a way for us to show off the accomplishments of our faculty, bring you here to the law school, and also give you a bit of free CLE. And we will offer 5 of these throughout the course of the year, 1 more coming up, and we will try very hard to make sure in December we are doing one of these that is ethics oriented. So anyway, Chuck Adams probably needs no introduction from many of you here. He has been an extremely active member of the Tulsa Bar, the Oklahoma Bar, the American Legal Institute, the ALI. Just looking at his resume, he has a master's in physics, which is interesting given some of the work that he's gotten into. Got his JD from the University of California at Berkeley. Has taught procedure, evidence, intellectual property. Also became very interested in cyber law issues and working across campus with some of the engineers in the cyber law department. Has published extensively, jury instructions, also extensively in law journals on a variety of civil procedure topics as well as evidence topics. And today is going to talk to us about legal issues involving digital forensics. So I'm going to turn the podium over now to Professor Chuck Adams.
Okay, thank you for coming. I'm going to be talking today about digital forensics, which is kind of the criminal side rather than the civil side of this area. And I want to start off with just some background on forensics in general. The Lockhardt's exchange principle, every contact leaves a trace. And so Lockhart was a professor in Lyon, France, the early part of the 20th century, and he's been called the father of forensic science, Sherlock Holmes of France, and his exchange principle summarized that every contact leaves a trace, and that it's the job of the criminal investigator to put those traces together. This is a more detailed explanation of that, but it's the foundation principle of forensic science. Basically, you go cover all these minute details and then put them together to build your case. The criminal investigator. And the application of this to digital evidence is that today a lot of the contacts that you have as you go through your life are digital in nature, and so it's a source of criminal investigation to not only look for the chemical or the ballistics evidence, but also digital evidence that may be lying around. And sometimes the criminal perpetrators will try to cover their tracks up, might try to erase the evidence, or they might even try to destroy it. I guess in the old days they could take their floppy disks and cut them up, and then nobody could find them anymore. Well, you can find it though. You just have to maybe use special equipment, maybe glue the stuff back together, but it can be found. The trace can be put together, and that's what these investigators do. Or you can even have hard drives that are burned up or destroyed. You can still get data out of them. It's harder. Or one type of digital evidence, cell phones. Cell phones are commonly used as detonation devices for IEDs, improvised explosive devices, in Iraq and other places. And they can also get blown up by suicide bombers. Typically, I understand from somebody who's investigated a lot of these that the last thing a suicide bomber does before they blow themselves up is to call their loved one. And so if you can recover the cell phone and get data out of it, then you can get a lot of information that lead to track down where the suicide bomber has been from. And there was an example of this idea of cover-up that the TU engineering department, computer science department, became involved with a number of years ago. It was a triple homicide where we had a mother and daughter who were living together, murdered by somebody, and then as he was leaving, there was a bystander coming by, and the murderer killed the bystander. So there were 3 people killed, and also the murderer tried to cover his tracks by burning the house down, so he set a fire there. And then he pulled the hard drive out of the computer and took that with him to cover his tracks. And so the police found some fingerprints there, but they weren't able to associate that with anybody because the fingerprints weren't in any law enforcement data file. And so they were stumped. And so then the TU computer science department came on the scene, entered the picture, and then they had to figure out how can you recover data from a hard drive that's disappeared. It's a tough problem, but they figured it out and broke the case because part of what they found at the site was some correspondence with a internet service provider, and then they got a subpoena. They got the police to get a subpoena from the internet service provider, got the records for the email, and then tracked that to a fellow in Tahlequah, and when the police went out and interviewed him, his prints matched. So he's now doing life without parole in a prison, and it could have never happened without I don't think, because the police were stumped with the investigation, without the involvement of the TU computer science students. And TU has become a world leader in this area of digital forensics, and partly because of this incident with solving this triple homicide like they did. And now, or after that, they set up a Tulsa digital forensics lab. It's in one of the apartment buildings over on Harvard. I'm nondescript, but on the second floor. And the badges there represent law enforcement officers, but there's also a TU intern office, and so the students in the digital forensics curriculum work with the police in investigating digital forensics, various crimes. They work with the Oklahoma State Bureau of Investigation, the Tulsa Police Department, and the U.S. Secret Service, which is involved in counterfeiting. That's often connected up with computers. So they get valuable experience, but the police say that they learn a lot more from the students than they give back, really, because the students have so much to contribute in this field. But the students also get valuable experience, which helps them, find very significant jobs in various parts of the government and with industry after this. So that's the digital forensics. But one part of the digital forensics is the legal issues that in doing these investigations you have to comply with whatever the legal requirements are, because part of it is the last step is to get this stuff into court. And so the one part of this is the Fourth Amendment to the United States Constitution, which restricts what the law enforcement is allowed to do in order to gather information as application to digital forensics. And the particular phrases in here that are of most significance in general are prohibits, the Fourth Amendment prohibits unreasonable searches and seizures, and requires warrants based on probable cause that are reasonably specific in terms of particularly describing what's to be searched. Okay, so first you have the requirement of probable cause. That's been defined in the Supreme Court case law as something more than just a possibility. Rather, what you have to do is make some kind of showing of a fair probability. It doesn't have to be certainty, but something more than just a wild hunch or a suspicion of something. You have to have a basis, a reasonable basis for the inference that you're going to find some contraband or evidence. So it's a particularized, not just a generalized suspicion, but something more specific than that. And in addition, the warrant has to specifically specify what's going to be searched. And an example in the digital forensics area involved a warrant. That's a 10th Circuit case from a few years ago that specified evidence relating to the sale and distribution of controlled substances. And while the investigators were searching this hard drive, they came across some JPEG files, some picture files with sexually suggestive titles to them. So they went and veered off and started searching those things too, found some child pornography, and then sought to prosecute the owner of the hard drive for that. And the 10th Circuit ruled that that was outside the scope of their warrant. So you have to have some specificity as to what crime and what types of information you're going to be seeking when the warrant's executed. Okay, now the process of investigating computers usually involves taking a mirror image of a hard drive so you can copy. That's the first thing that's done, the whole hard drive onto another hard drive, and then the investigator uses specialized tools, forensic tools, to search that hard drive. The purpose of that is so that you don't alter anything on the original. You have the original untouched, basically. It's just copied over, and then you mess with, like having a sandbox that you can play with without really affecting the original hard drive. And the question that is raised, is that really specific enough? If you can copy the whole hard drive that could contain all kinds of things on there that's outside the scope of the warrant, is that permissible? A recent case from the 9th Circuit has upheld such a search, and it's based on the idea that you can, if you have contraband or evidence in a container, that the law enforcement is allowed to take the whole container and then search through it to find the particularized subject of the search warrant within that. But it's not quite an easy fit, is what I'm trying to say. That the technology brings up some unusual legal issues that the courts are called upon to resolve. And one recent law review article argues that there's a doctrine called the plain view doctrine, that normally if the law enforcement comes across things in the course of conducting their normal activities, that's fair to use if it was in plain view. Well, when you're searching through a hard drive and you come across things that it doesn't quite fit well, and the cases haven't said that yet, but that's at least an argument that's been raised. So the specificity of the warrant can become an issue. You also have some exceptions to the warrant requirement. The warrant requirement comes in only if you have unreasonable searches and seizures. And one exception that's been recognized, a bright line exception that's been recognized in the case law to the warrant requirement, is the search incident to the arrest doctrine, which authorizes law enforcement, when they arrest somebody, to seize anything, including things having, containers having things in them, and then search the contents of all the containers that they have. Well, this could include, today, the title is "The iPhone Meets the Fourth Amendment." It could include all the information that's on, an iPhone is basically a little computer with a telephone attached to it. It can have all sorts of information on it, or other types of smartphones or cell phones, and this could apply even to arrests for traffic violations that the police under this, and it's a bright line rule developed in other cases to allow people to search things, law enforcement to search things. There are no cases on it, but this article from the latest issue of the UCLA Law Review argues that if you extend it just a little bit to digital evidence, that you have that kind of a result. Another exception that's very well recognized in the cases are border searches. When you're come across the border, then you'll see the drug sniffing dogs and be going through all your luggage. What about computers that you might have? Can the law enforcement go through those? And this has been a very old, well-recognized exception. A recent case from the Ninth Circuit held that, yep, they could. Immigration officials, customs officials at the border, could search a laptop and find child pornography. So somebody coming in to the LA airport from the Philippines opened up his laptop, started looking around, and the suggestive titles for these files, and prosecuted somebody, and conviction upheld. So that's a recent case illustrating that exception to the warrant requirement. And last December, there was a story in the USA Today a couple months ago about the experience of this character who travels a lot, and in his work, he's an engineer in San Jose, and whenever he travels, they go through his iPhone when he enters the country, and his computer. And I don't So what he has to do, or what he's been doing, is he erases everything before he leaves the country, backs it up, and then when he comes back, he restores it to his iPhone and his computer. I don't know. I mean, I'm not trying to say that it's right that the officers are doing that to this individual, but I would think that it's not. I mean, at least I think it's credible what he says, given that getup that he's wearing and so forth, that they would be investigating story about that sort of thing that's been happening. It's not in the cases, but I think it's kind of an extension of that Arnold case that I just had put up before, involving the search of the laptop computer. Anyhow, are there any questions instantly before I... Okay, now, one problem, another legal problem besides Fourth Amendment dealing with admissibility of evidence that's obtained from computers is the issue of reliability. And in evidence law, there's a prominent line of cases called the Daubert line, named after a case involving products liability for drug Bendictin, and testimony about whether it could be a basis for liability on account of causing birth defects when given to pregnant women. And this line of cases ruled that the trial judge is supposed to be gatekeeper to keep out unreliable evidence, and it listed a number of factors for the court to consider. How reliable is basically what they're talking about, but you can break it down into various factors under that. And then that raises the question: is how reliable is the computer forensic evidence? And the answer, I guess, kind of depends. For computer forensics, for like desktops and laptops, you have a reasonably mature science. Even though they've only had individual personal computers for about 20 years, they've developed pretty much standardized techniques. So you have hard drives that you can pull out of them, do mirror images, and they conform to technical standards in order to be interchangeable in these things. And they involve the use of mirror images and standardized forensic programs. And there's a variety of them that the TU students are trained to use over here. They go by various names. There are specialized programs for investigating these things. And generally, the Daubert standards have been satisfied with normal computer forensic evidence. There hasn't been any case that's thrown out computer digital evidence on account of Daubert. Just this last week, there was a report of the National Research Council about other types of forensic evidence, or all types of forensic evidence, ballistics, fingerprints, DNA, and what have you. And it's very critical about a number of these other areas, but they have only a few pages on digital forensics in there, and basically all they say is that it would be helpful to have, or they recommend, uniform training and certification requirements. So, I mean, you have to know something about computers, I guess, in order to be doing digital forensics. But other than that, it's pretty reliable if you have people who know what they're doing, is I think the summation of the National Research Council report. It's a little different with respect to cell phones, though. Cell phones present kind of different issues. They're not, the investigations for these things aren't quite as well advanced. Part of it is the storage devices in cell phones tend to be proprietary and non-standardized. They vary from one phone to another. They're not made to be interchangeable, that you can pull things out of them easily. You can't really pull a hard drive out very easily. I guess you can do anything, but it's not set up to just unscrew it and unplug it. You have to do some more physical stuff to dig the memory, which isn't necessarily a hard drive, out of the cell phones. And you can't really make mirror images. They don't have the same technology for making mirror images from off the memory in cell phones. And so you're kind of dependent on, for example, it's pretty well known that just because you erase something in a computer doesn't mean that it's gone. Okay, and it's true of cell phones too, but it's a lot easier to recover what's erased from a computer hard drive than it is from a cell phone. You have to go through the operating system, typically in the cell phone, and if the operating system won't allow you, it's very hard to get at the data. Now, it's not impossible, but you have to be a little bit more creative, and the techniques aren't as standardized, and they vary from one cell phone to another, and so forth. So cell phone forensics is in some ways much less advanced than computer forensics, but there still can, and so you may have trouble satisfying the normal Daubert standards for admissibility. This doesn't mean, though, that you still can't use the data recovered from cell phones for some purposes. It's just that, in other words, to get leads, to get other evidence, that's possible. In other words, you can get a wiretap order or a subpoena possibly, because the standards for reliability are not as significant or as high as if you're trying to admit the evidence in court. So the reliability is more questionable of the data recovered from cell phones, I think, than from normal computers. Now let me talk a little bit about the Fourth Amendment again. So it's not, even though it's not otherwise admissible, it could have other uses for law enforcement. For example, you can use it to obtain telephone records from the service providers, or maybe get a wiretap order, and then get evidence that would be very reliable and then could be admissible. Okay, now let me return to the Fourth Amendment for a minute about unreasonable searches and seizures, and talk specifically more about wiretaps and emails and so forth, getting access to those things. Historically, slides kind of messed up here. Historically, in 1928, there was an old Supreme Court case which ruled that the Fourth Amendment didn't preclude wiretaps because it wasn't really a search. The Fourth Amendment only covers unreasonable searches and seizures, and when we're talking about a wiretap, it's not really a search of anybody's house because there's no physical intrusion. You're just listening in at the telephone company when you tap into the line or outside the house somewhere. But this was overruled this Olmstead case was overruled in the days of the Warren Court with a couple of cases, Berger and Cass. Berger involved a planting of a bug in an office. The court held that was a search, even though they weren't really taking anything. They were just recording a private conversation. The Cass was an interesting case. This one wasn't in anybody's home, but a public telephone booth. And the court held that there was a rule that there was a reasonable expectation of privacy there, and so that the Fourth Amendment did apply to wiretapping. And that was kind of a surprise because before that there had been the Olmstead case, which held that there was no problem with that. Later cases, though, from the Supreme Court have limited the search doctrine somewhat. The Hoffa case, well, it wasn't really a later case, it was about the same time, but an extension of Hoffa, a couple cases extended Hoffa, dealt with statements to an informant. third party. If you have third party involvement, then if you volunteer to somebody some information, and you may think that they're your friend, but if they happen to be wearing a wire and it's being recorded by the police, well, you have no expectation of privacy anymore in that. You may be surprised that they turned on you, but it's not a reasonable expectation of privacy, and the police can use that against you. Related to that in some way has to do with the Miller case, which involved bank records. Bank records are things that you don't have a reasonable expectation of privacy in, the Supreme Court ruled, because they're turned over to a bank, a third party. And if a bank can have them, then if the bank wants to turn them over to the police aren't really doing a search when they take the bank records from your bank. Similarly, another case, Smith versus Maryland, involved what they called the pen register, which is just information on what number is dialed from a phone. This would appear like in your billing records, and phone companies keep track of that for billing records, and the Supreme Court ruled, well, this is another third-party type of property that when you turn it over to the phone company, by dialing a number, you're telling the phone company what number you want to call. You have no expectation of privacy in that. So these cases from the 70s are the latest cases from the Supreme Court in this area. They don't really address telecommunications or computers or anything, but they have application to that, and they are relied upon by the courts in determining the scope of the Fourth Amendment. And they seriously undercut the protection that's given by the Fourth Amendment to things like emails and to telephone calls. And Congress, though, has reacted to the Supreme Court's decisions from the 70s and the Hoffa decision from the 60s. Well, the Miller case in particular, there's a Right to Financial Privacy Act, which does provide some privacy. It's not in the Fourth Amendment, though. It comes out of this legislation that protects your bank records. So when I say that there's less protection for bank records, it comes from statute, not from the Fourth Amendment. And in addition, they have an Electronic Communications Privacy Act, which has various components to it. One deals with wiretaps, and what this does is it kind of goes even beyond the Katz case by requiring what's been called a super warrant for a wiretap order. Okay, you have to show not only probable cause to get a wiretap order, but you have to go beyond that and show some other things that weren't required by the Fourth Amendment. But that was a concern that Congress had with the idea of wiretapping. In addition, you have to show, for example, a necessity for the wiretap in the sense that you can't use you can't get the same information by other means, and law enforcement has to maintain records for some period of time and notify the person after the wiretap's over that they've been wiretapped and so forth. So there are various things that have to be accomplished with a wiretap order, and it's in a fairly complicated statute, 2518, that I'm just barely scratching the surface of and summarizing. For stored communications, and this is where emails would come in, you have special provisions that you can get a court order to obtain email records. Okay, but the showing that's required for it is something less than probable cause. It has to do with, basically, government has to offer specific and articulable facts, whatever that means, but something more or less specific, to the court that the contents of this stored electronic communication, that's been turned over to the internet service provider and is stored someplace, is relevant and material to an ongoing criminal investigation. Basically what that is that the government can get one of these things if they have a fishing expedition. Okay, if they have some reasonable suspicion, and it has to be an official fishing expedition, but they don't have to have the kind of particularized cause that you would need for a warrant. okay, because it's a different standard. So this allows much more accessibility to emails as opposed to intercepting the telephone communication. Now, an interception of an email wouldn't be a stored email, so it has to be some email that's stored in the server, the text that's stored in the various servers that you could get the subpoena for under this 2703D as opposed to a wiretap order. So there's a distinction made between intercepting communications and recovering stored communications. Recovering stored communications are akin to bank records that are stored someplace and don't have the protection absent of the Fourth Amendment, absent the statute. And then there's a pen register statute, which is based on the Smith versus Maryland case, which involved this telephone calling records, where again you require a court order, but you can obtain a court order by making a showing that it's relevant to an ongoing criminal investigation rather than some kind of particularized need. So you can get what are called call detail records, information on numbers that are called, which can be a valuable source for law enforcement of information opposed to the contents, but you can find out who somebody's calling, how long the call was, the date of the call, and so forth in these call detail records. So, and then there's also another piece of legislation called the Community Assistance for Law Enforcement Act. I'll get into that if I have time in a couple minutes, but the idea behind this is to cover changing technology. As the telecommunications system evolves, it's been replaced from analog to digital and so forth, and they're constantly upgrading it. The law enforcement got concerned that when they changed it, when the telecommunication industry changed the system, that they wouldn't be able to get their wiretaps anymore because it wouldn't be technologically feasible. So they put in the law that whatever they did to their telecommunications system would have to provide in some way that if the law enforcement got warrants for one of these orders, that the law enforcement could get hold of the information anymore. Okay, so that's the Community Assistance for Law Enforcement Act. Okay, so this addresses changes in technology. So that's the statutory framework, a very basic summary of the statutory framework that applies to in the digital forensics area. It's primarily regulated, rather than by the Fourth Amendment, it's regulated by this maze of statutes. And these statutes were primarily written in the 80s. So they more or less cover technology from the 80s, but they hadn't really thought about at that time a lot of the advances that have come since then. Okay, so how does this apply? Basically, for telephone calls that are intercepted and emails, you need to get a wiretap order, and it requires this super warrant where you need this particularized showing of probable cause. But for stored emails that are just sitting around in the Internet Service Provider's server, you can get those things with a much lower standard 2703D order, or for the call detail records, you can just get this pen register order. Again, it's just relevance to a criminal investigation is all that's required. I was just talking about call detail records briefly. These, the way the telecommunications system is set up is you have the cell phone sending a radio signal to a tower, then that goes through this network that connects up with the telephone network, and then eventually gets connected to a telephone. And in this maze, you have all kinds of data that's being recorded by the network all the time. And this is the type of information that the call detail records can get at. They can't get the contents of the telephone calls, but they can get types of information, including telephone numbers, time and length of call, and where the calls were coming from, their locations. Okay, a number of years ago, in the 90s, the FBI developed a system called Carnivore to enable them to do digital investigations. The FBI was slow in getting into the field for various reasons, but then they wanted to get into the field of digital forensics, and so they came up with this computer program, and I guess there's a lot of testosterone in the FBI because they named it Carnivore. It might have been better if they'd called it Bluebird, or what they eventually changed it to is something less threatening. I mean, DCS 1000, or something like that, but they called it Carnivore. And it had this logo, which you can't see too well, but it's like these jaws with blood on them and so that was this very menacing appearance to this program that they had for investigating internet service providers or customers of internet service providers. And the basic structure of this thing is you had the internet service provider on the left there, and then you installed at the internet service provider's location a collection computer, and which didn't have a monitor or keyboard or anything. It was just a keyboard sitting there that was a one-way tap in sucking off information as it went through the internet service provider. And this could be emails, or it could be IP addresses. So if the target of the investigation were looking at different things on the internet, this could record what they were looking at, as well as any emails that they were sending out of their computer. And then this went to the control computer, which would be at FBI headquarters or some kind of law enforcement headquarters. And this is basically an example of something that's known as a sniffer. And you can get these easily on the internet. Some are free. Some, they have a description of them here. What they allow the user to do is pick up traffic on the internet, and you can just download one of these and then put it into a network. And so the FBI was sort of a specialized application of a sniffer, but it was set up to handle law enforcement requirements. And you had basically two screens. You had a fairly simple screen here, the basic screen with a start and stop button for the recording session for the FBI to use. And then they had more of a advanced one. And I don't know if you can see it too clearly, but here. Button they were supposed to use. If they used the full, that meant they had to have a wiretap order to get the interceptions. But if it was the pen, it was the pen register, and they would hit that bullet, and then they would just pick up the address information. The Wall Street Journal, sort of broke the story in 2000 about this, and that led to a big outcry. I think as motivated as anything by the name of the deal. The FBI, what it was really trying to do was limit the information that it was tapping into. It wasn't looking at everything. It was going to be limiting it to whoever they had for a warrant, which is authorized, or if it was a pen register. But the public got concerned because they were afraid that the FBI would be using this thing to just look at everybody. Okay? And the trouble with looking at everybody is they didn't have the bandwidth, the capacity to look at everybody. It would only work if you narrowed it to particular people looking at specific times. But they did a big investigation, and there was basically concern with FBI abuses. The FBI wanted to keep this thing secret. One problem is that the computer at the FBI's or the ISP location wasn't secure, and they didn't have carefully controlled login procedures, so it was hard to tell exactly who was using it and when and why. So you had anonymous users and inadequate physical control, and sometimes you had some bugs in the system too. So after this huge outcry, the FBI abandoned this project, and I guess they've been pretty secretive since then about what they've been doing, and haven't let it leak to the FBI. So, there were some concerns, but that's a story about an attempt at digital forensics that I guess wasn't very sensitive to public relations and also some possible legal issues. Let me talk next about just briefly about cell phones and tracking location information from cell phones. Cell phones, as I said, work by sending a message to a tower. And this is I think the closest tower to the law school here. It's at Admiral and Harvard. They're about every half mile or so. And they have like a three-way array there. Okay, and the way the cell phone works is you have when you have an incoming call, it finds out where your cell phone is and sends the incoming call to the nearest tower, and then from the tower it sends a radio message to your cell phone and tells you to answer it. You have some ringtone that it will cause to go off in your cell phone, and this the cell phones can be used to track people as a result, because they have to know which cell tower you're near in order to send a message to you, unless you turn it off. But as long as it's on, you're sending continuously a message to the cell tower telling it where you are, that you're at one cell tower rather than another. So if you have an array of these cell towers over a landscape, and they're going to be about half a mile or apart or so, and then you have somebody moving through the countryside, then they'll be passing it off from one cell tower to the next, and you can trace where somebody's going with that. So you can get location information on people. This could be very valuable to law enforcement, because it could tell you about things like alibis, where somebody was at a particular time when the crime was committed, because all these things, they record exactly what time it is that you're passing each cell tower, and you can triangulate between them because there's this three-way thing, and you can maybe get within a pretty close location. And in Britain, they use this quite a bit, and they can combine it with videos, because they video people in various locations around Britain, and so you can really find out exactly where somebody's been going. And this, so you have this progress from one to another, and you can tell that some cell phone, if it's been on, has been along this road at a particular time, or anywhere you want to go in the countryside. So law enforcement has a real interest in getting this kind of information, and the question that's been coming up over and over again is, what authority do you need to obtain this location tracking information from law enforcement? And there have been about 20 cases in the last 2 or 3 years at the district court level. There are no court of appeals decisions on this, so it's one of the most hotly litigated areas in the field. One possibility would be a warrant, but the difficulty with a warrant is in order to get a warrant, you need probable cause, and you have to have a crime that's already been committed. And sometimes what they want to do is just investigate people before the crime's committed, and they don't really know that there's going to be a crime committed. They just want to do an investigation. And so there's been a lot of pressure to try to figure out a way to use the Stored Communications Act. You have data that's sitting in these cell towers, and can you get the data through a 2703D order that I've talked about, or a pen-registered statute which lets you get call detail records? Could this fit within either of those, or do you have to have the probable cause to get a warrant? And basically, if we're trying to talk about historic information, I think that either the pen register or the 2703D order would work. But the trouble from a practical standpoint is the data only stays around in the network for a short period of time, and there's not a way to get the past data for very long. You really won't want to do it prospectively. You're going to be using it for law enforcement. And so what the cases have basically been saying is that you need a warrant. And part of that has to do with the statutory authority here. I mentioned this CALEA, this Community Assistance for Law Enforcement Act. When this was going through Congress in the 90s, one of the senators, Senator Leahy, raised a concern about whether this could be used for tracking people, because this was sort of a new thing, and he asked the FBI representative, Director Free, if they were trying to track people, and he said, no, we're not trying to track people, and Lee said, fine, let me put it into the statute that you can't use it to track people. So they did. Okay, they put in the CALEA statute that you couldn't rely on solely pen register authority to find location identifying information to track people. Now for landlines, it's not a problem because you know where the landline is, but we're talking about trying to track people with cell phones because they're carrying these things around. And the Stored Communication Act also had in it some other provision that prohibited the use of tracking devices as a basis for getting stored communications. So between these two pieces of authority, basically, as I say, there have been about 20 published opinions since 2005 involving these. An example of one fairly, I guess the most recent one from 2009, but you can track back about 20 of these things. They argue basically through this maze of statutes, and most of them have come out saying that you need a warrant, but there is some division which have allowed the law enforcement to get the tracking information prospectively without having a warrant. So that's probably eventually going to get decided by some higher courts, and it would be interesting from standpoint of both defense and from law enforcement. So I think I have some more material on other topics, but I think I'll quit here. Any questions from anybody about what I've covered? Yeah, Steve. Well, they have different names for these things. I think in the previous slide it referred to pen register and trap and trace devices. Pen register was the outgoing, the trap and trace device was the incoming call. They were both authorized though, and they define pen register in some generic sense now. It had a particular physical definition at one time. I'm not exactly what a pen register looked like or was, but now it's defined statutorily to cover any kind of recording of caller ID type information. So it covers both ways, basically, to and from. Yeah, Chris? Uh-huh. Right. Yeah, it's something held by a third party. That's the whole key to it. Some third party rather than the person with the specific privacy interest in it. But the way these things work is they're stored, by third parties, so they're pretty easy to easy to get hold of them that way. And they're stored at multiple locations, not just one computer. They could be several computers in the network, the way emails work. Okay, well, thank you for your attention. Have a good day.